Welcome to Our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to a special New Year's episode of Our Curious Amalgam. The title of today's episode is, Will the Past Be the Future? Looking back at 2024 and forward to 2025. 2024 was a killer year for news and developments in antitrust, competition, consumer protection, and data privacy law. We couldn't possibly talk about all of these topics in great detail in a single episode, but in the limited time we have, we'll be highlighting some of the hot topics of 2024 and making some educated guesses about what we might expect to see in the coming year's headlines. But before we talk about that, I'd like to welcome first my fellow mistress of ceremonies, Anora Wang. Hi, Anora.
Hi, Alicia. Glad to be here with you at the beginning of a new year.
And now let's say hello to the rest of the gang, starting off with Derek Jackson of Cohen and Gresser. Hi, Derek.
Hi, Alicia. Really happy to be here and Happy New Year.
And welcome to Brendan Coffman of Wilson Sonsini. Hi, Brendan.
Greetings. Thank you for inviting me, and I'm looking forward to this great panel.
And now let's say hello to James Hunsberger of Axinn.
Thanks, Alicia. Great to be here, and Happy New Year.
Happy New Year to you, too. And finally, Matthew Hall from London at McGuireWoods. Hi, Matthew.
Hi, Alicia. Good to be here.
Well, let's get started. First up is Derek, and he's going to talk about what's been going on in the criminal underworld of antitrust crimes.
Thanks, Alicia. And looking at criminal antitrust in the past year, I think the main theme we really see is a continuation of trends from the earlier years of the Biden administration. In particular, I think three things sort of stand out. First, enforcement levels overall remain pretty steady, but they continue to be lower than peak enforcement levels that we saw 10 or so years ago. So looking at the stats the DOJ puts together for us and presents nicely on their website, in fiscal year 2024, there were 5 corporations and 20 individuals charged criminally. And that's really a pretty similar level to what we saw in 2023 and really to the past several years. But that's sort of well below peak levels. In 2015, we saw, for example, 20 corporations and 66 individuals were charged. And there's been a lot of discussion about that decline over time and whether it relates to a decline in leniency applications or something else. But we seem to be at sort of a steady level now where enforcement has been similar over the past few years. And looking at fines, it's a similar story. There were only $10.6 million of criminal fines in U.S. antitrust in 2024. And that's a lower figure than we saw last year, largely because we didn't have one big sort of splashy fine in the news as we did prior with the generics drugs case. But it's sort of a similar level to what we saw in 2022. And again, below peak levels that we saw 10 years ago, which I think is a combination of both the number of cases and the type of cases that we're seeing. And that brings me to my second point is we continue to see a focus on domestic cartels in terms of the new cases that are being charged. And in particular, we're seeing a lot of cases emerging from the DOJ's procurement collusion task force related to bid rigging and government contracts. And these are mostly in domestic industries and in areas like transportation, construction, asphalt paving, concrete. And we're seeing less of the big international cartel cases that drove up some of the really high fine numbers in past years. And I think the third trend that we're seeing is a lot of continued focus on no-poach cases and in the labor market. And despite a few trial losses in recent years, the Biden administration continued to be focused on these type of cases. And while we haven't necessarily seen any new cases reported in the press in recent months, DOJ officials have continued to confirm in speeches that they have a number of active investigations in that area and that they haven't been deterred by some of the trial losses. So looking forward to the new year and in a second Trump administration, I think unlike what I expect we'll hear in some of the other areas of antitrust policy we're talking about today, I actually expect that criminal enforcement will be fairly steady and kind of continue along the same path, both in terms of the levels of enforcement and in terms of areas of focus. I think a couple trends worth watching will be one, what does happen with those labor market cases? On the one hand, we might expect that a Trump administration would be a little less focused on labor markets, and given some of the trial losses, might pull back a bit on no poach enforcement. But on the other hand, the first no poached cases that we saw filed were actually filed at the end of the first Trump term. And so, it is possible that the division will continue to focus on those types of cases. I think they'll certainly continue to focus on procurement and bid rigging cases. And then the second thing I think will be interesting to watch will be their approach to the leniency program. Of course, the leniency program ends up being the source of many of the criminal antitrust cases we see under the Biden administration. The leniency program was tweaked in a few ways, largely trying to increase individual accountability for corporate executives. During the last Trump administration, the Trump DOJ more broadly did roll back some department-wide guidance about individual accountability. This was the Yates memo that came into place at the end of the Obama administration and then was rolled back. So if they take a similar approach this time around, it's possible that also results in some rolling back or some changes to the leniency program. Again, on the other hand, the current administration has touted that 2023 saw the most leniency applications that they had seen in a decade. And so, maybe the new administration will take a sort of if it ain't broke, don't fix it approach and continue on with the current approach to leniency as it was changed.
Thanks, Derek. That's a great wrap-up of 2024 and a prediction for 2025. Now let's move on to monopolization. Brandon, do you have anything for us?
I sure hope so. Well, thanks again for inviting me. So 2024 was, of course, a huge year for monopolization. There's certainly no way to cover everything that happened, but we're going to touch on some of the big picture items. Quote-unquote big tech has been a key focal point for monopolization enforcement for several years now, and there were several major developments in the marquee cases. Obviously, Judge Mehta held that Google violated the Sherman Act with respect to distribution agreements for general search services and general search text ads. That case is now in the remedies phase. I can't speak about the case in any detail, but I do share the observation that the outcome of the remedies phase in that case will be a very important and impactful antitrust development moving forward, probably one of the most important decisions in antitrust history. The DOJ also just dropped closing arguments in its ad tech monopolization case against Google in the Eastern District of Virginia. The FTC survived a motion for summary judgment in its monopolization case against Meta and a motion to dismiss in its monopolization case against Amazon, allowing both matters to progress to trial and discovery, respectively. And perhaps galvanized by these successes, more Section 2 cases have been filed this year. Of note, the United States sued Apple, alleging that Apple uses critical access points in the smartphone ecosystem to deter customers from switching to other smartphones. The DOJ sued Visa, alleging monopolization in debit transactions, and alleging that Visa leverages its size and network to entice merchants to enter into, quote, de facto exclusive routing contracts. And finally, the United States filed a monopolization case against Live Nation and Ticketmaster, alleging monopolization for the market for live music events. And this included acquiring smaller regional promoters, executing exclusive long-term agreements with venues, and restricting artists' access to venues unless artists agree to certain promotional services. One observation on these cases that have progressed or recently been filed is they all allege monopolization through a series of tactics, and in each matter, the government goes to great lengths to explain and allege how different types of conduct combine to reinforce the alleged monopoly. This is a trend I think is likely to continue until met with resistance by the courts. To that end, there is one case that I do want to highlight that perhaps went overlooked by several who follow antitrust developments on a day-to-day basis, and that is from the Fourth Circuit in the Duke Energy Carolinas versus NTE Carolinas private suit. There, the plaintiffs alleged that the defendant had engaged in an overall scheme to exclude it from the wholesale power market by a series of tactics that included terminating integration agreements, making economically rational offers to supply, filing for breach of contract, intervening in permit applications, and things of that nature. The district court, in dismissing the case, analyzed each component separately. So, for instance, they used a separate sham litigation and a separate predatory pricing mechanism to look at each piece of the conduct. But the Fourth Circuit overturned and ruled that when a party alleges a complex or atypical exclusionary scheme, a court must analyze the scheme as alleged and not in manufactured subcategories. And this is of note because in almost I think literally all of the previous cases that I just mentioned, this Fourth Circuit opinion was quickly submitted as supplemental authority. And this is one that plaintiffs, both the government and private plaintiffs, are looking to as perhaps the new roadmap for how to allege monopolization cases moving forward. So with that, I'll pause and share it over to the next person.
Thanks, Brandon. Another key area is M&A, of course, and then focusing in the U.S., we will have James to give us an update and an overview.
Thanks, Anora. It has been an exciting and very busy year in M&A antitrust. As our listeners know, since taking office in 2021, the Biden administration has pursued an aggressive enforcement agenda against mergers. And in the final year of the administration, the FTC and the DOJ have doubled down on that approach. Under Biden, the leadership at the U.S. agencies has shown their continued preference to challenge transactions rather than accept negotiated settlements. Notably, neither the DOJ nor the FTC agreed to any settlements in the past year that involved the divestiture of assets, which is the traditional remedy for solving potential agency concerns about mergers. That has led to a number of litigated challenges and court decisions this year. And while the agencies over the course of the 4 years of the Biden administration have had a mixed track record challenging deals, they have had some notable wins in merger litigation in the past year. In our limited time today, I'll focus on a couple of those agency wins. First, in the proposed merger of low-cost airlines JetBlue and Spirit, the DOJ persuaded a district court in Boston to block the deal in January of 2024. The parties then abandoned the deal in March. The DOJ focused its case on the close competition between JetBlue and Spirit for airline travelers that are interested in low-cost options, arguing that the merger would eliminate JetBlue's main ultra-low-cost competitor. The DOJ's theory was largely a traditional one, built on evidence showing that the merger, in their view, would increase prices on routes where the two airlines currently compete. This marks a second major court victory for the DOJ against JetBlue in the last couple of years. As our listeners may recall, in May of 2023, the DOJ successfully blocked JetBlue's earlier strategic alliance with American Airlines, and that decision was upheld on appeal by the First Circuit in November of this year. Second, in the proposed merger of fashion companies Tapestry and Capri, the FTC persuaded a district court in New York to block the deal in October of 2024. The parties then abandoned the deal in November. In that case, the FTC focused competition between a few of the company's leading handbag brands, many of which our listeners may be familiar with. On one side, there's Tapestry's Coach and Kate Spade brands, and on the other, there's Capri's Michael Kors brand. The FTC alleged that these brands are particularly close competitors in what it defined as the relevant product market, which is, quote, accessible luxury handbags in the price range of $100 to $1,000. Many observers in the antitrust bar viewed this market definition with a certain degree of skepticism, as it appeared to be artificially drawn to capture the merging parties' handbags while excluding other companies' similar handbags. But nonetheless, the district court ultimately agreed with the FTC's market definition, and the FTC won the case. While the narrow market definition may make the case look novel on its face, it's actually a pretty straightforward decision from the district court. The court's decision relies on traditional tools of market definition and merger analysis. In particular, the court relied heavily on internal documents suggesting the companies are particularly close and key competitors to one another. And based on this evidence, the court dismissed testimony from the company's executives that attempted to establish the FTC's market definition was too narrow. The court also relied on the traditional structural presumption based on the parties' high market shares and did not go along with the FTC's view under the new 2023 merger guidelines that the transaction should be found unlawful based solely on a loss of head-to-head competition without analyzing market shares. Stepping away from litigated challenges, another important development in 2024 is the FTC and DOJ's release of the final version of the new rules for pre-merger filings in the United States, known as the HSR rules. This was recently covered in depth on episode 297 of Our Curious Amalgam, but the bottom line is that the new rules transform the HSR process that has been in place for decades and impose a number of new requirements on merging parties. The new requirements are intended to address what the FTC and DOJ leadership perceive as a gap in the information that they have to review mergers during the initial 30-day waiting period after parties file a merger notification. Unless withdrawn by the FTC or otherwise delayed, the new rules are scheduled to go into effect in February of 2025. So briefly, what lies ahead? We'll have a new presidential administration in DC starting on January 20th. It remains to be seen what antitrust enforcement policy will look like under Trump 2.0, but most observers are expecting an overall environment that is likely to be more favorable to deal making than the Biden administration. New leadership at the DOJ and FTC could lead to important changes on a number of fronts, including the new HSR rules, the 2023 merger guidelines, and agency policy on the pro-competitive efficiencies of mergers and remedies to address potential concerns. While some change in antitrust policy is expected, many observers anticipate continued robust enforcement under Trump 2.0. Antitrust has become an important political issue, and politicians across the spectrum have expressed support for strong enforcement.
Thank you, James. That was a great review. And as you mentioned, there is so much going on, and there's going to be a lot more going on, and lots more fodder for future Our Curious Amalgam episodes, I'm sure. Now, turning to the international side, I would like to ask Matthew Hall to tell us about 2024 and what he thinks might happen in 2025.
Thanks, Alicia. As you say, I'm covering major developments outside the US. This can, of course, only touch on some of the issues. My first topic is enforcement and interpretation of Article 102 of the Treaty on the Functioning of the European Union. That's the provision prohibiting abuse of a dominant position that affects the EU. On 1 August 2024, the European Commission started a public consultation on a draft of new guidelines on how to analyze exclusionary abuses of dominance. So think cases such as Google shopping on self-preferencing. Exploitative abuses are not covered. The consultation has closed, and the Commission plans to finalize the guidelines during 2025. Next, merger control, which continues to evolve worldwide. Again, looking at the EU in 2024, the long saga concerning Illumina's acquisition of Grail came to an end. As a reminder, Grail had no revenue in the EU, but still the Commission claimed jurisdiction over the deal and blocked it due to vertical foreclosure concerns. The top EU court ruled in September that this claim of jurisdiction was an overreach. There is now a lot of discussion around the world about how to deal with problematic acquisitions such as this that fall below standard thresholds. At the moment, the main weapon is to use general call-in powers. Countries such as Italy and China use such powers in 24. By the end of 2025, perhaps 2/3 of EU countries will have this power. Also on merger control, the deal value threshold in India is now in force, and during 2025 will likely require many more transactions to be filed. Australia will likely move to a mandatory and suspensory regime starting 1 January 2026. Considering policy issues more widely, the intersection of competition law with industrial and trade policy was widely discussed in 2024. The new EU Competition Commissioner Ribera, who started in December, was instructed to implement a, quote, new approach to competition policy, which will include being more supportive of EU companies scaling up in global markets. So as part of this, early in 2025, we are likely to see a review of the EU horizontal merger guidelines. This may include a broader acceptance of efficiencies arguments, including resilience and perhaps an innovation defense. These policies could, of course, impact global deals and spread more widely in 2025. For example, proposed amendments to the COMESA regime expand public interest considerations. Moving on, the application of competition law to environmental sustainability issues also continues to be important. There are already guidelines from various competition regulators around the world on cooperation between competitors in this area, and several provided informal guidance on specific topics or cases during 24. In addition, Singapore and Korea introduced guidelines, and Australia consulted on a draft in 2024. Looking forward, in 2025, Kaye in Brazil will introduce horizontal collaboration guidance, including a section on environmental sustainability. We may see this issue considered in the context of abuse of dominance. In the UK, there is already a private claim based on this. The issue will also increasingly be important to merger control, with sustainability issues being raised as both a negative and a positive factor. On another antitrust topic, as Derek mentioned in relation to the US, but similarly elsewhere, labor market issues continue to be important in 24. Kaye in Brazil opened 2 new proceedings to investigate the exchange of wage and benefit information. Turkey published guidelines in 2024. And in the EU in July 2024, the Commission started an investigation into an alleged no-poach agreement in the food delivery sector and is looking at another case in the data center construction center. Finally, FDI, or foreign direct investment rules, continued worldwide to be a big issue in 24. Canada introduced changes. Singapore introduced a regime. Ireland is introducing a regime during 25, and Germany will be introducing significant changes. Also, keep a lookout for developments in the area of outbound investments from regions including the UK and elsewhere. So that's my brief contribution on major developments and trends outside the US. We've covered several of those and indeed other issues in previous Our Curious Amalgam episodes. Over to Anora to introduce our next section, and thank you.
Thanks, Matthew. That's a great overview in a short time, but covering a lot of areas and a lot of topics. Now let's switch gears for a little bit and focusing on consumer protection. Again, maybe a little bit of US-centric, but Alicia, you may give us a little bit of a rundown of the developments and predictions in 2025.
I'm happy to do it. Developments and trends I chose have a couple of things in common. I chose 3 topics, 2 pocketbook issues, and 1 very novel, perhaps controversial issue. We'll see what happens. A lot of these have only just gotten started, but my prediction for all 3 is that they're going to continue to gain momentum. And I don't think that any political changes will necessarily have much of an impact on them because, in fact, I think that they are issues that are important to consumers no matter what political flavor they happen to be. And politicians like them because they are so important to consumers and voters. So the first one is junk fees. As many people know, there was federal legislation introduced in 2023 that would govern the ability of businesses to include surcharges and fees on top of advertised prices. This is a hot button issue because so many consumers are so frustrated by doing price comparisons. And then when they go to make their purchase, whether it's a hotel, a restaurant, or in some situations where they're more or less captive, such as loan servicing, they find additional fees piled on. And they're not little either. The fees are sometimes quite large, and the price can approach double, what they thought the price would be. So the Junk Fee Prevention Act on the federal side is something that's under consideration. I'm going to make a bold prediction and guess that I think something like it will pass. This is bipartisan legislation, as I mentioned. At the state level, however, the states have already started enacting laws, and I think we're going to see more of it. So far, there's the honest pricing law in California. Minnesota has a full disclosure pricing law going into effect this year, 2025. New York is now requiring entertainment venues to disclose the total cost of tickets. And Connecticut also has a disclosures bill pending. The FTC and the Consumer Protection Financial Bureau have been bringing actions on a regular basis against junk fees, misleading price advertising. We'll probably see more of that. And of course, the class action lawyers are not at all far behind. There have been some very large suits brought and some settlements reached, and that too will continue. Let's then talk about price gouging. Again, consumers are feeling it in their pocketbooks. Price gouging was in all the headlines during the pandemic, and there were cases brought under various state price gouging laws. I think 45 states have price gouging prohibitions. They typically go into effect during declared emergencies, and they will restrain companies from jacking up the prices of food and other essential items. So we saw masks being sold for ridiculous prices, or hand sanitizer being hoarded and sold at incredibly high markups. But this has gone on beyond the pandemic. I think that politicians, consumers see price gouging whenever they perceive a price to be too high. And there's been calls to action. including a more recent one by 15 state attorneys general, led by the Attorney General of New York, to urge Congress to pass federal price gouging legislation that would not preempt the state laws, but would at least set a floor and that would apply across borders. So we will see what happens on that front. There will be many companies affected, including companies that trade in commodities with sometimes volatile price changes based on supply and demand, where prices can, again, go up to very high levels, but also can drop to low levels. How will they be affected by price gouging legislation? And the last thing I want to talk about on the consumer protection front is the cases against currently Meta, which operates Instagram, based on the theory of social media addiction. That is, these platforms, the way they interact with minors, teenagers in particular. The allegations are, and these are cases brought by a group of attorneys general, state attorneys general, and then there's a separate Massachusetts case, all of which are notable for being based on the allegation that the platforms are designed to tap into teenagers' fear of missing out. They will encourage teenagers to scroll endlessly. The way that they function by creating opportunities to like or dislike or comment and so forth, the allegation is it's very damaging to the mental health of teenagers. This is a pretty novel theory. These cases have not been dismissed. That is, motions to dismiss by Meta have been unsuccessful. So these cases at the moment are going to proceed to discovery and potentially even trial if they can't get over the probably inevitable summary judgment motions. So those cases will be very interesting. There are, of course, other platforms that have similar aspects, and they will be watching this case very closely. Class action lawyers are also in the mix as well. And finally, let's not be completely U.S.-centric. I would be remiss, since I'm the consumer protection person today, at noting that in the UK, recent legislation has now empowered the Competition Markets Authority with much more authority to bring enforcement actions, make it easier to bring enforcement actions, and impose larger fines on consumer protection violations. So we can look forward to increased activity. I think that's going to be inevitable in the UK on the consumer protection front. That wraps it up on the consumer protection front. So now, last but certainly not least, I'd like to ask Anora Wang to talk a little bit about what's going on with data privacy.
Thanks, Alicia. A lot is happening in the data world. Admittedly, maybe not just in the U.S., but also the rest of the world. It's still at an earlier stage of legal development in the sense that, like, the laws are being considered, enacted, and went into effect, which is sort of like a continuum of trends in the past 2 to 3 years, which is, as I predict, is going to continue in 2025. What we have seen in the U.S. is that we're seeing at least 4 states that have had their data privacy laws went into effect in 2024. That included the Texas Data Privacy and Security Act, the Montana Consumer Data Privacy Act, the Oregon Consumer Privacy Act, and the Tennessee Information Protection Act. So this is against the backdrop of several other states that have enacted laws to protect the data privacy in 2023. And a couple other states are considering bills which might provide additional varying standards of data privacy in the U.S. Ohio and Michigan may be a front runner. Which brings to my second observation, which is that we're seeing more and more of a network of varying standards of data privacy in the various states in the U.S. And that could be a thing to change because there has been at least noise, if not educated prediction that there may be a federal law that will finally make this patchwork more of a universal or standard legal standard for the United States. What I predict is, perhaps as many of you would see, is that several of these laws on the state level that have went into effect in 2024 might see first time enforcement in 2025. And that would probably clarify just how different these legal standards are. So that's pretty much in the US. in the EU, we also see some laws that have went into effect or being enacted in 2024 with a bit of focus on AI. And that would include the EU Artificial Intelligence Act that went into effect in August 2024, the European Data Act that was enacted in 2024, but would go into effect in 2025 in September. So that's sort of like a similar trend like the US, but we do see a little bit of a focus on AI, not going along with the legal changes, not just having more laws. We actually see agencies having more investigations, focusing on AI and focusing on particular actors. So seems to be a similar trend in the US and in the EU. We're also seeing in the rest of the world, like in the APAC area, or including Israel, we have seen new laws and new legal changes being discussed or being adopted in 2024, and that's a trend going to be continue in 2025.
Thank you very much, Anora. That's a great description of what's going on with data privacy. Thank you to everybody who participated in this New Year's special. So thank you to all of you, and thank you to listeners and subscribers. So tune in to Our Curious Amalgam in 2025.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.